everyone. Welcome to our webinar on habitability law updates here for Colorado. We got lots to talk about, but we'll get kicked off here in about 60 seconds so we can get people to file in. Plus, I always like to make sure that people can see us and hear us and see our screen. So if you guys type in the chat box that you can, and or let us know what part of town you're in or what part of town, where in Colorado you are, let us know. We like to know where people are. And then also, we like to stay interactive, so feel free to keep asking questions or dropping comments throughout. All right, we got some people rolling in. Oh, we got someone from Trinidad this morning.
That's
a
new spot.
All right, Florida, lots of Colorado. All right, go Highlands Ranch. Awesome, great. Thank you, everyone, and good morning. Glad to see lots of people. Brandon, kick us off, my friend.
Yeah, what an exciting topic today. Excited to be covering this. A lot of this stuff comes from legislation that came about in 2024, but there's kind of a tail on these things of actually seeing how it rolls out, what kind of lawsuits bubble up from it. So there's just a lot to talk about here. I'm excited to jump into it. Today we've got Chris Lopez, co-founder of Property Llama Capital. Myself, I'm the CEO of Keyrenter Denver, and we have Wes Wallenweber, attorney at, well, I won't attempt to say that right now.
You got his last name.
Attorney,
correctly,
period.
So that's what matters.
You're way ahead.
Yeah, I'm excited, guys. We did a webinar, I think 4, 5, 6 weeks ago, and it was phenomenal, and had more requests for doing it. Yes, this meeting is being recorded. I see a few questions in there. All right, guys, I'm gonna ask you first, Brandon. Like, why does this matter? You're a PM, you're the front lines. I'll turn to you, Wes. Why does this matter, Brandon?
This is a big deal. It's basically, we've had this shift that's happened over a number of years, and you can kind of pinpoint to a few pieces of legislation, but it's been a general trend of a real tightening up of how warranty of habitability is defined, interpreted, and what it means to just like provide a habitable house to a tenant, and what happens if you don't, and what it looks like to remedy that. There's a lot to it. So that's what we're going to be walking through today. There's very strict response deadlines now. It used to be a lot of vague language of reasonable and things like that. And yeah, now they've hit us with some real specifics, but there's still a lot of gray area there to interpret. So
same question to you, Wes. Why does this matter?
Well, this matters because I have to tell you, it's great to be back. Thanks for getting me up to the microphone there. Appreciated you guys have me on for the first time with security deposits. That matters. But out of all the things I've helped landlords, ownership entities deal with, we got our first Warranty Habitability Act, maybe back in 08. I'll talk about that maybe for a second. But this matters because this is what I like to call the cauldron of suffering.
Cauldron of suffering.
I am representing
the webinar headline.
I'm representing so many landlords that are getting hit with not just demand letters from tenant advocates for warranty habitability claims, but full-on lawsuits. And the three of us talked a little bit about that this morning. And it's really putting landlords of all sizes and shapes through a gauntlet of figuring out how to resolve those claims, whether to give it to insurance, will insurance even cover it once you've tendered it, and just helping them work through it. It matters. Mark Cunningham, who we were talking about, that's been a long time NARPM leader, he told me when he saw these amendments, because we've known each other for years, he just said, Wes, this is an avalanche. It's just going to be open season for lawsuits on landlords. And that wasn't just prophetic. It really has been the truth. Out of all the stuff coming through my door, 95% of it are allegations that the landlords breached the warranty habitability. And it matters because it's allowing tenant advocates to dovetail this claim with other legal claims, which we'll get into. And they're pretty potent claims if you've really had a problem. So Brandon and I were talking, you buy a building that's just got some older maintenance issues, deferred issues that aren't your fault, and you're trying to get up to speed on them, and you're being good to your tenants, but one water event happens, suddenly you're going to potentially be blamed for some of those things that have just been laying around dormant under the surface. So it matters a lot.
Let's talk about kind of some of the changes, because the habitability is not new. but it's gone through, I think it was this year or maybe last year. I can't remember. Very recently, it's gone through a lot of changes.
It really has.
So start walking us through this, Wes, with kind of like first, kind of like what's the timeline on there?
Sure. One thing I want to say first, to be fair about this law, is I told you guys last time I'm a pretty moderate thinker when it comes to leasing issues. Find myself somewhere in the middle. Back whenever we got this first Warranty Habitability Act, we didn't have one, and I think we were a very pro landlord state because of it. And Mark Cheddar and I at the time, worked for him. We were very close friends, still are. I said, Mark, we're eventually going to get one. And so it came, and you got to get in front of it and be part of the early legislation, or you're going to get run over. So I was part of the very first Warranty Habitability Act. Mark Cheddar drafted great sections of it to work with tenant advocates. And I think it was a very fair, reasonable act that we probably did need here in the state. But now, to answer your question, Chris, it's gone through quite a few iterations. And these last changes, even for me, a moderate thinker, they're brutal. They're really hard for landlords to comply with. And what we have on the slide right now are the two really big chunks of this new amendment. Now, the prior amendments, Chris, they did put a bigger burden on landlords to commence repairs on something that could be an inhabitable condition. You had to get after it a little bit quicker. I thought that was brutal enough, but then came these two requirements. So if you've got something, a condition that's going on in a unit that you own that materially interferes with life, health, and safety, you now have this 24-hour response window. For everything else that's habitability issue, but doesn't maybe necessarily affect life, health, or safety, it's a 72-hour response window. But let's just talk really quick, Brandon. What are these response times? What's the clock? What do you run it from?
That's a tricky one. I mean, it could even be, you could have a maintenance guy out there working on something unrelated, and the tenant mentions, oh, by the way, I saw this too. That can start your clock.
Exactly.
Right. So you just got to be careful. If you catch wind of it anyway, it starts that clock. For us, it says must begin remedial action within 24 hours. So for us, we've contacted the tenant, acknowledged the receipt of it, provided some of their rights, because that's part of the requirement, so they understand. And then we also kind of let them know next steps, as well as we kind of we fish a little bit for them letting us know if they think this is a habitability issue, and a resource on how that's defined.
Because I'm guessing like a tenant's not calling saying, hey, I have a habitability issue, right? They're just saying, hey, the heat's out.
Exactly.
Okay.
And then you got to know whether it falls into this 24-hour category A, or is it something else in category B that gives you the 72 hours. But this timeline is pretty strict. And I was working on a habitability response letter for a client yesterday. The tenant's law firm name, just so we get it out there, that's handling a lot of these warranty habitability claims. Now, you're all going to think I'm just making this up, but their name is Sue My Landlord, LLC. And
from a marketing standpoint, that is,
and I know the folks at Cheddar Souls or Muccio, Springer Braden, some of the landlord advocacy firms have been dealing with them. And I was telling Brandon, I really liked the female attorney I was dealing with there. I think she was a social worker turned lawyer. And on this particular claim, it's probably pretty legit, but the demand letter taught me a little bit more about this deadline. Not only do you have this 24-hour response window, and we're going to talk about it in another slide a little bit later, but just to preview that slide, you got 24 hours to commence something that's going to solve this dangerous condition. But in that window, you've also got 7 days to try to bring it to some kind of conclusion. And when I first saw this legislation coming through, I shared last time that I sit on Colorado Bar Association body that is called the Legislative Policy Committee. I'm not on the LPC, but I meet with the LPC, and we see all kinds of bills come through. So the real estate section of the bar is the one that works with the AMD, NARPM to negotiate some of these bills. So I was just sitting around, and I saw these amendments coming through in late 23 and read the statutory language, which is at CRS 38-12-503. I've been a lawyer 26 years, Brandon. When I read that language, in 503, I have to read it 25 times over and over again to even understand what it means. So this legislation matters because it's not as clear as it could be. And it gives tenants the ability to argue some things when that language could be a little tighter, about 24 hours. And then you got to get it done in 7. I just find that it's really a brutal standard for any landlord.
Yeah, especially like on a plumbing issue or something like that. If it all of a sudden, okay, there's a little bit of a flood involved, you might have to get out and test for lead before you can do certain things. It's just, yeah, that sometimes it's really tricky, even if you're as diligent as you possibly can be. And in a lot of situations, I think the tenant's understanding of that, and it doesn't turn it doesn't immediately turn litigious, but yeah, there's certainly a big burden and an opportunity for them to say you didn't meet that.
Wes, are you saying that within that 7-day window, it's got to be essentially remediated and fixed?
Potentially. We're going to delve into that in another slide. So it's a great question for our overview. I look at these new amendments that we're staring at there as having 2 components. As we've had for a while, there's a deadline on a landlord to commence. Let's stick with that word for a second. Commence a repair. Get after it. You've got that 24-hour response window or 72-hour to get moving on it. And Brandon's going to kind of take us through some ways we could, help our folks, our mutual clients get after that 24, 72-hour window. But then there's a part B that we're going to get into. Commence and conclude. And they could have wrote the language, the General Assembly, the drafters of this amendments on that second part to be a lot more clear, but I'll do my best to help navigate it. For me, when I saw these amendments come through, to use a skiing or I'm a snowboarder analogy, with warranty habitability's last changes, I looked at it like, even as a lawyer, boy, I got to figure out what they are, how to help our clients navigate it and protect themselves. I looked at it like a double black, like, yeah, I'm finally there. I get it. I'm giving good advice. These 2 amendments came and they're like gigantic moguls on the slope. Oh, crap. How do I get down these moguls? I'm not sure I even understand what the language is saying. So I'm just trying to help clients navigate this stuff that we're going to talk about in these next slides. So, yeah, we're going to have to talk about how you wrap up the repair. I don't know that it means you have it completely fixed, but we'll delve into it a little bit and kick that topic around.
Okay, so I think we already went through. So, when does the clock start? So essentially, anytime the tenant reaches out to any team member or any type of technology you have, right? Phone call, text, email, the tenant portal submission, the in-person that you mentioned. Hey, they mentioned to the tech.
Anybody, it's like it could be an
happen?
actual agent of your company or someone the tenant perceives as an agent of your company, right? So that's tricky, but go ahead.
I would say, so basically, yeah, once they mention it, the clock starts. A question here in the comments, it says, who determines if the 24-hour response or 70-hour response window has been violated? Or does that come down to the Sue My Lawyer LLC?
That's a great question. Who determines that it's been violated? I guess if you go into the future and you've had a dispute over it, it's going to be a court of law that'll determine it. And I think the statute gives judges a lot of discretion. I haven't seen a jury trial on this statute yet, so that would be interesting. But I guess to answer that that particular question, who determines it? You're going to have advocates that represent tenants or tenants themselves that are going to accuse you of violating it, and you're going to have to respond. And then if you get sued, who's ultimately going to determine it is a court, just like they would on any lease break. Lease breach issue. But while we got that slide up, that second button, the tenant portal, I just wanted to comment where I'm seeing a lot of allegations from tenant attorney advocates is that tenants have gone into those portals and the management company that's fee managing or whoever it is that's responding in the portal isn't responding quick enough. So I just want to point that out. Delay is being used against some of my clients quite a bit. And any kind of habitability issue, bed bugs, mold, water intrusion leading to mold. There was one where some voles were found in a property and it was mentioned in the portal. So I just want to encourage everybody, if you use a portal system, make sure somebody's monitoring it like a hawk, because that documentation will be used against you that, well, instead of responding in 24 hours, you took 72, 4 full days. The portal's being used against people. Why? Because it's a tracking device.
Yeah, and I think in the old days there was a lot of, okay, use your portal for everything non-emergency, and maybe you have a template response that says, hey, if this is an emergency, pick up the phone, call this number. But that may not be good enough with some of this of, like just putting it back on them to define their own emergency and stuff.
Yeah, and I think property management groups have just got to invest some time right now teaching your folks to document these things a little better as they come in. Documentation is the weapon to show you're trying to meet these timelines.
All right, getting the details about kind of like what the law says. I think you guys have mentioned a few things about what's the 24-hour, what's the 72-hour. Getting into some like details here, please.
Sure, I'm gonna let Brandon lead off because your company invented these slides. When I first read them, I thought they were phenomenal. They summarize super well what the obligations are. So Brandon, you take that left column and I'll fill in some gaps.
Yeah. So one thing that was an emphasis here is leasing an uninhabitable unit became something that they really frowned on. They don't want to see that. But a lot of what we're talking about here is basically there's these two tiers. So it's like if it's a issue that affects life, safety, or health in a material way, then it fits this first bucket. That's the 24-hour to get started on it. If it affects those things, I guess in an immaterial way. So typically what's falling into that, we call it the 505 list because the statute, the last
I like that,
end of it. But our 505 list, it's mostly like appliances, AC, things like that, that are like a lesser kind of, it's not like obvious the house is completely not livable at this point. So those hit that 72.
And the AC is not part of the habitability. AC is not, but heat is, right?
Well, yes and no, I would say.
Okay.
My understanding, maybe Wes, but heat, yes. If it's like cold and you have no heat, that's a bigger issue than if it's hot and you have no AC. But AC is basically treated as a more minor tier habitability issue if it was advertised or there when they moved in. Basically anything that was there when they moved in. In the old days there was a lot of it's there but I'm not fixing it. That was kind of a lot of landlords liked that kind of posture.
Right.
This did away with any of that, right?
Okay.
So if you advertise something, if it was there when they moved in, it's probably gonna be like, then you need to maintain it, need to fix it.
That makes sense.
Yeah.
No, that was really well said. Really agree with that. You're dead on right about that.
So here is it, going back to a slide or two. How can an in-person conversation be confirmed? What if that on-site service rep forgets or delays mentioning anything? Brandon, I feel like that would be one of the things. If I was in your shoes, I would probably lose some sleep over once in a while.
Yeah, I don't know. It's a good question. I think like Wes, you sit in court more than we do, so you might know on this, but I think sometimes it's like you're not going to lose the entire case on them saying verbally. If it's just their testimony that they told you something and it took 2 days to respond, but then from there you hit every deadline and all that, like you're probably not going to lose on that piece alone. But if you show a kind of pattern of delay or not hitting deadlines, like it gets worse for you.
Yeah, one, I agree with what you just said, and two, I've seen that play out in court. Absolutely. That's where documentation's just so crucial. But yeah, if you have somebody on your team that spaced something out, the minute you found out what they spaced out, the quicker you get on it, the better it is for your situation. And I would never view these things as you just give up. Like, oh, well, we're too far behind the 8 ball. Who cares? That's what you're going to dig. A grave, So you got to get after.
Yeah, that's a good way to think of it. You can always keep digging. So
exactly.
Don't keep digging.
Yeah, exactly.
And on that note, kind of about, I think, showing, hey, your best intention with complying. I think it goes back to like, and I've had this attitude for years and working at real estate. A lot of landlords have like an adversarial relationship with their tenants, where every other business is like, hey, treat your customer right. I've always been like, well, yeah, I want to like treat my tenants, my customer right. Because they're living in a property that's $1 million to me, like, please don't screw it up. I'm worried about you returning a $20 item. Like it's a lot more on there. So I think a lot has to go, like, if you treat your tenants or you treat your customers, right, with respect. I mean, my experience often goes such a long way when there's an issue or miscommunication. or like, oh yeah, this broke, but no, the landlord's been great to me. Like, no, this is just get this fixed, right?
Yeah.
Like, I think that should be said. Just like treat people well,
Totally.
and that I think handles a lot of issues as well.
I do too. If I was your judge right now and you were the tenant and you were the landlord, and I felt, you were a little behind the 8 ball getting started, it's down a water intrusion issue that led to discovery of some mold, which we're going to talk a lot about today. And I felt you've been really reasonable. And I'm trying as your judge to interpret this 24-hour and 7-day thing. To me, I'm not saying all judges would be this way. If you've been really reasonable to your tenant, yeah, I'm going to give you a lot of brownie points for trying to comply with this law. But we'll just have to see how judges see these cases.
You used one of my favorite words lawyer says, and that's reasonable. Define reasonable.
Marchetta and I
takes this next slide as well, like reasonable.
Yeah, if you're in the Fair Housing Act, there's a pretty set definition. Like say with accommodations, it means whatever's feasible or practical. But with this stuff, it means whatever a court decides is reasonable the day you're there. So the more you can document and show what you've been doing and what your vendor's work is, the better. Documentation is key on this. I was really struggling with this one yesterday because 2 vendors came in to clean up a water intrusion issue. And then I shared with you, Brandon, we discovered that this building had a lot of different plumbing issues and there's probably some underlying mold. So the major argument was that the first vendor didn't protect the area, blew mold spores all over their possessions. It was the second vendor came in, did an exceptional job. So I'm trying to ferret all that out through documentation. Why was there 2 different vendors overlapping with each other? So the punchline is we've really got to be documenting this stuff well to show that you're responding reasonably.
All right. So on the right-hand side, we got the 7-14 days. Is this for that portion where they're supposed to be, I think you said completed?
Yeah. So we're looking at 3812-503. Justin at Brandon's office did a great job with this slide because this is
Jeremy.
I'm so sorry.
Job.
Bad with names at times, guys. Sorry. He did a phenomenal job. This is pretty heavy duty stuff. 5033A requires repairs to be completed in a reasonable time frame. The law defines this as a failure to commence and remedy or repair. That's kind of that completion word I was using within this time frame. So over on the right with the health and safety, you're on this 7-day time clock with no clear guidance from our legislature on whether you've met that 7-day time clock. It's vague language, repair or remedy. Well, how do you know whether you have fully remedied something, especially a water intrusion issue that keeps moving and breathing on its own? As we all know, even in an arid state like Colorado, mold grows.
Mm-hmm.
So for me, that's really problematic because I don't quite know how to advise everybody whether you fully remedied it. What I do know is you got to rely on your third-party experts that are coming in. And we'll keep talking about that as we go through these slides. Brandon, on that 14-day deadline for everything else, I guess it would be the same thing. Do you feel like you're wrapping up the issue? For me, the way I see it and came to make up my own mind on it, Chris, yesterday, is are you getting a handle on the problem so that whatever the long-term issue with is not going to be problematic anymore?
Sure.
Let's take a water intrusion issue. Have you really gotten water extraction done so that it won't start growing mold? Have you done that in the 7-day time span? I think that's the primary burden of this 7-day clock. But it is a 7-day clock, and that's absolutely brutal.
Because we can all agree, like, it wouldn't be reasonable that you're going to stop the leak, flood cut the wall, get in the dehumidifiers, all that, and then patch it all back up and paint it and get the baseboard back up and redo the flooring. Like, that's not a 7-day job, no matter how diligent you are. So I think maybe it's just an unreasonable timeline and judges will see that, or maybe it's like what they're meaning is you've stopped the leak and gotten it dried out or something.
And that is exactly what I'm hoping and praying it means, because that's what maybe you can get done in that 7 days.
Actually, before we move on here for the litigation triggers, there's a couple comments here, or questions I should say in the comments. I think it's Jeff asked, is there a statute of limitations for this? Can I be sued after a tenant leaves the property?
Weirdly, they didn't define the statute of limitations very well. So I'm going to have to get back to everybody what I think it is. Answer to that question is two parts. One, yeah, you can be sued after they've left the property for it. But when you really read the statute, this is all about funneling down to, does the tenant have to get out? Like if you've really got some bad habitability issues, we all know this is giving tenants an out from a lease. I think it's going to be really hard. Part two of my answer is to sue landlords well after you're out. But there's a caveat. Let's say I'm the tenant and I had a mold issue. And now I've learned that I've got trichothecenes in my blood. And I've got some kind of toxicologist expert saying, I think you were exposed to long-term mold. You got mycotoxins and there's a poison in your system. And I find a plaintiff's law firm out there to say that the breach of the warranty habitability now gives me a personal injury premises liability type claim. Yeah, you're going to potentially get sued. And we really got to pin down what that statute limitation is. But premises liability is typically, a 2-year window from when you knew or should have known that you've got harm from it. Whether that's going to allow the warranty habitability claim to be brought that late, I don't know yet. But lawyers are going to figure out how to merge that warranty habitability claim into some other kind of legal claim and get beyond, say, like a 1-year statute limitation or something like that.
So one more question here that really stood out to me. Cheryl says, I'm a vendor with a question about these conditions and drug contamination. Are drug contaminations part of the habitability issue?
Yes, they are. They're very dangerous conditions. And, before we ever even had a Warranty Habitability Act, I would see local environmental police sections of the police. The municipalities had these environmental departments. I don't know if you ever saw it, Brandon, but somebody cooked enough meth that suddenly the unit, there was a drug bust. The cops are really concerned about it. They force you to do an eviction and an FED. So we've always viewed meth, now fentanyl. I have housing authority clients where we're dealing with these issues. Absolutely triggers warranty habitability. And that begs a huge question. How on earth can you remedy that problem in 7 days?
How do you remedy meth in 7 days?
How do you remedy it in 7 months? It's just a colossal problem. That's how asinine some aspects of this 24-hour and 7-day timeline are. So that was a great question. I think it just really takes time to, at that point, you're probably getting somebody out of a unit, evicting, and having to go through really extensive remediation where the Colorado Public Department of Health, Environment, whatever agencies under them that's going to give that unit a clean bill of health, like Tri-County Health, you're going to go through all those steps. And I don't think you can be sued for warranty habitability just because you're going through those steps. What else can you do? You got to do what the law that's above this law is requiring you do to remediate, clean that unit up, and somehow make ready habitable for somebody else in the future. So I think it just trumps and overrides this altogether.
So let's talk about actually kind of what triggers litigation, right? Because just because a tenant reports it doesn't mean a lawsuit gets filed. And
True.
Obviously, like, a tenant filing a lawsuit or sending a letter, that's, a big step above emailing you through your portal, right, Brandon? So kind of what triggers from, I'll say from any legal standpoint, and then maybe Brandon and any like, customer service things that you do along the way to help like mitigate that risk.
I think these 5 things that we're presenting up there are dead on. They're really, from my standpoint in the legal circle, Phil, these are the big 5 triggers. When you fail to get after the repair in that 24 or 72-hour window and really get behind the 8 ball, that could trigger a demand letter from a tenant, a pro se lawsuit from a tenant, or a tenant advocacy firm coming after you. Second, starting repairs, but then not really finishing them up, continuing them. I think that word continuing that's in bold is great when we talk about that 7-day deadline. Like you're trying to bring things to conclusion as quick as you can. And if you're delaying that, not figuring it out quick enough, that could trigger. That leads right into delays. That dovetails into delay. If you're delaying, like say you just got a vendor that doesn't have the right answer, and then you sit on the problem for 2 or 3 days, and the tenant then goes to a hotel or something like that. I'm seeing those things really triggering a tenant to have an appetite to come after the landlord. Leasing an uninhabitable condition, that's just like putting a sign "Sue me" on my back. Brandon and I were talking about somebody in your industry that rented a really nice home in the mountains, but that home really was uninhabitable. It had some very hidden problems, and an owner that probably went to some great measures to do it. Just don't be in that world. If you know you've got some uninhabitable conditions, do whatever you got to do to fix them.
And don't try to cover it up, right?
Don't try to cover it up. Like my best friend rents some properties in the Fairplay area, and I would also say a trigger on number 5, ignoring attempting to conceal. Sometimes you don't even have to be a nefarious landlord to conceal something. Let's just talk about that for a minute. That 5th one's the big one. So my buddy, I'm sure he'd be okay sharing this. He's really conscientious landlord, loves his tenant. And he's offering something in a weird part of Colorado for people that maybe have 6-month jobs, school teachers. Well, he found a water leak near one of the bathrooms and kind of went in and looked to see if there was maybe some manifestations where there could be mold. Typical things, water bubbling, black mildewy looking stuff. But the question then is, do you just clean up that one little spot, or do you investigate a little bit further to see where it's really emanating from? What's the origin of it? And are you going far enough? Because if you don't, and the tenant discovers mold further down into the vanity, somewhere further down where the real source of the leak is, then even though you weren't trying to conceal anything, you're going to be accused of concealing, that you hid it, that you covered it up and didn't go far enough. The greatest weapon any tenant or a buyer of a property that finds mold has is when it's just laying beneath the surface and they try to make the allegation that you knew or should have known.
And you recaulked it, but clearly there was an issue there.
Yeah, and it doesn't mean you got to do drywall cuts all the way down to the next bedroom and do demolition. But you got to rely on a vendor to some extent. Like, how far do we need to be looking at this? Have we found the source of the water?
They do all that. I mean, like, I've remediated a few things, and then I was like, oh, you took out like 10 more square feet than I thought you were going to. Like,
yeah, you're right.
Because they have to make sure, like, hey, they have to get it, which I mean, I think is a good thing. It's like, oh, wow, that is.
Well, this really raises the issue that there's no right answer. But when we're looking at that 5th one, yeah, you don't want to be in that spot where maybe you didn't go far enough to figure out. This is really more related to water intrusion. I've lived with so many water intrusion issues in my client's life over the last decade that they're hard. But if you're not finding the source of it quick enough, this is what you're going to get accused of, and what's going to trigger litigation, that you either A, ignored it, B, attempted to conceal it, or C, just blew it.
You almost have to take the lens of, like, imagine you're buying this property and you see that. How much due diligence would you do to make sure that doesn't indicate a further issue? Like, then my standard goes way up. But if it's like, oh, I'll just cover it up, paint over it, like, you're setting yourself up to maybe get in trouble.
And with what Brandon just said, I don't want to be trite about this, but that was really profound. I think that's kind of the standard now to avoid these triggers. You can't always meet it. It can be tough. But I'll just use the word lens. You said that. The lens I'd look at it through is like if I was the buyer. I think that's a great lens to just say, as a property manager, landlord, what are we going to do with this event, this condition, to make sure we've addressed it? I think that's the lens to probably look at it through. Tough lens to have to look at it through, unfortunately.
I don't know if you can share this, Brandon, or I don't know data, but like, have you guys experienced lawsuits with this new law yet? And I'm curious if you notice any patterns as to kind of like a certain step in the process or certain things that you're like, hey, if this happens, we're more likely to get, a lawsuit, or we've done this to help, like, mitigate that from just the, the process and customer service aspect.
Yeah, we're dealing with our first 2 of them right now, one larger than another one. One of them, I don't know that I can answer your question with like one specific thing. I would say in one case, it kind of comes down to like a vendor who maybe didn't follow the right process, and it was a vendor we had good reason to trust and that kind of thing, but just kind of sloppy along the way. Yeah, I don't know. It's like, for me, it's like such a shift, right? There was a time where it's like, you get a little water in the basement and you're like, yeah, it's going to be, do we want to turn this into insurance and get out the mitigation company? And it's like a whole to do, right? And it's a big old ordeal. Or do we just get a guy out who can pull the carpet back, put up a couple of fans, make sure it dries out properly, like restretch the carpets, like $500 or something. I mean, that was just the mentality you had to make money in rental property, right? Of we got to keep.
I've also done it on my own home before.
I know,
right?
totally.
Like,
So it doesn't feel that crazy,
Yeah,
right? Like
right.
use like the sniff test. Is there something that really says there's a mold problem here? I don't think so. So like, let's not test. Let's just like, yeah, if there is, well, it'll manifest itself at some point, or we'll see some other issue. But yeah, this just has shifted to like you got to take this stuff more seriously, and it is more expensive, and it's eating into cash flow, and so it's painful. But yeah,
and I think it's a good thing to kind of like take a step back. If you're in the process of buying a property turned to rental right now, like I think with these new laws, I would be extra diligent on just all the tests and all there. And
Yeah.
I agree. I think you said let's treat it like it's your own home. And like, hey, a lot of people in my own home, I do radon tests. Not my home, don't do radon tests.
yeah,
Things like that. Where I think if you're, you should always do a radon test, whether it's your primary or rental. But if you're buying a property or rental right now, I would just do add way more due diligence inspection times on there as well, because you don't want to walk into a problem like this and like, oh crap, all right, well, I'm paying $30,000 for hey, you're the seller, what you did or previous homeowner did 10 years ago.
yeah.
Yeah, I told you guys we're probably going to have to do a part 2 to where we can answer questions about is there a specific statute of limitation and how do you navigate lawsuits. But Chris, I think you just gave our listeners the best piece of input we could through this whole topic today. Yeah, when you're going to acquire a property, I think you really do have to look at it, because to answer your earlier question about these triggers, the biggest thing I'm seeing that good tenant advocates are arguing and using to their advantage is there's probably just some kind of underlying condition that you didn't even cause, that was there before you bought the property. Plumbing issues, just old pipes. They want to hang you out to dry for the end result of it. So I think what you just said, really great advice. What I'm seeing in these triggers with the lawsuits, yeah, I'm handling several of the lawsuits, several demand letters. And if I took a complaint, the lawsuit, or a demand letter and just looked for key buzzwords we see in this slide here, what the lawyers are arguing the most: delays, that you delayed. This came through the portal. Like I said earlier, you didn't get after it. Insufficient action. You, with water intrusion, didn't get air purifiers in, dry it enough. You nailed it. The old days of just pulling up the carpet, drying it out, leaving the subfloor, it's not good enough. And not going far enough with these more extensive health and safety things. And then finally, another trigger is, have you taken a final step before you bring a tenant back in to say, we really got a clean bill of health there? And that's a tough one. That's what I'm seeing in these allegations as buzzwords: delays, not completing it, not going far enough, not doing thorough repairs, dropping the ball here, dropping the ball there. But good news, when you funnel it all down, the bigger allegation has been around delays. So what can we learn from it? If we're getting after it, like we keep talking about, beating that horse to death, and we're documenting it, as crazy as this 24-hour, 7-day is for these bigger ticket items, I think a lot of landlords are going to be okay. You're going to you may still get hit with the demand letter, but you may be able to defend your position a lot better, that you got after it as quick as you humanly possible could, documenting it. I want everybody to look at your vendors' invoices, though, and work with your vendors to show that they're doing everything possible. Like, they may do a great job, but what if their invoice in the services column doesn't show that they were drying everything out, using air purifiers, doing this or that? How are you going to prove they did it? Well, if you get sued and the technician from that third-party vendor comes in and testifies, great. But lean on them. I did that yesterday with a large management company. They called their vendor to put stuff that they had actually done in that invoice, because we need it for documentation. So work on that with your vendors.
That's smart.
Yeah, have that documentation in that they really, did a lot of specific things that meet what you're being required here in 503A to do.
And I agree with you. In my experience in life and business, and judges and mediators, if people are like good faith trying and they can document things, like goes a huge way versus like, oh, you were trying to cover this up, or you just you ignore 10 phone calls.
Yeah, it's a great
Yeah.
point. I was mediating as a mediator a warranty habitability case before I ever defended one, since I'm still doing some advocacy work. And I just told the tenant advocates, this landlord's done everything humanly possible to fix pretty much an unfixable situation. So you could maybe lose your case. I would take a reasonable offer, call it a day. That was my perspective on that particular issue. So I think that's a great point.
That was your perspective as a mediator?
As a mediator.
Did you
And
convince them to settle?
yes.
All right, good.
And in those situations, hopefully lawyers are looking at a gray-haired guy like me as kind of a pseudo judge. They want me to not necessarily give legal advice, but they want me to be evaluative. So I said, yeah, come on, let's look at this from a reasonable lens.
Yeah.
I think we've already talked through the slides for protect yourself, communicate, document, try your best. What about water and mold risk? I know we've already touched on here, but that is, as we all know,
all right,
water happens and it's the worst thing on property.
This is a slide that some of our listeners at home may have thrown some coffee on, spit on, like, what do you mean? We got to start looking at all this in-depth mitigation stuff. To your point earlier, Brandon, back in the day, I think when we had water intrusion issues and some of these more complicated things to clean up, the issue was, if you go too far, do you open a Pandora's box? What's really lying under the surface, and do you want to get there? So one of the issues I've been dealing with as a lawyer advocating for landlords that have some of these bigger ticket problems with water intrusion, plumbing problems where the same line keeps breaking, gas leaks, things, some of these help.
Or like the chronic backup that you have
great.
from a
sewage.
Oh, yeah.
Yep, sewage.
I've got one of those personally that I'm like, what do I do other than replace
Yeah.
that whole line? Because we can't get ahead of it.
We kind of lived in a danged if you do, danged if you don't world under these two amendments to the Warranty Habitability Act. So this side, dealing with water intrusion and mold, it is controversial. But with these harder issues, you've got to engage people that really know what they're doing with mitigation. Because what I'm seeing in the bigger lawsuits, Chris, with mold, are allegations that the third-party vendor didn't know what they were doing, didn't seal off the areas. They're making drywall cuts and trying to solve the water intrusion issue. And tenants are getting better than average mold tests now. So then they can try to show some factual scenarios where their stuff's not covered up properly. It's not contained properly. So easier to argue in that situation that mold spores that they're arguing are showing up in their lab reports from an industrial hygiene mold report are getting on their stuff, and that they need new mattress, they need new personal belongings. And so that's really, to me, really important, that we got to raise the bar on who's coming in. I've seen a couple cases recently where an owner of a property just didn't engage the right water extraction company, then didn't engage the right mold mitigator. You've got to do that. But then that leads to a really tough question. Do you do, as a landlord, your own mold testing? And that's a really tough question to answer. I put there in that bottom line, it's possible you want to do it, but boy, I really want you to talk to your legal counsel about it. And if I'm your legal counsel, what we're really going to talk about in an attorney-client privilege situation is whether it's really necessary or not. Now, I haven't made up my mind yet when a landlord should do their own mold testing. But let's talk about this as a playing field. If the offense that's coming after us on defense is testing for mold, to say this property is not given a clean bill of health, this apartment unit, this condo unit you're renting me, this single family home you're renting me, it's toxic. These levels aren't safe. And you've done all this remediation work. How are you going to counteract that if you don't do your own testing? So I'm a big fan of industrial hygienists. I've won some pretty big trials where tenants have claimed that they've been harmed by mold. Shared even last time one where the gentleman was sick from mold. Turned out not to be the landlord's fault. I think he may have poisoned himself. But I've become a fan of industrial hygienists. They win the day on these cases, and they can help guide us too on when to test. I talked to a gentleman yesterday who I plan on using a lot. He's an excellent industrial hygienist. He thinks one of the answers to whether you test for mold in your own unit might be, how much water have you really had and what kind of water was it? And believe it or not, despite 26 years of doing this stuff, he used some terms I hadn't heard. Maybe you've heard this before. He talked about like class 1 water, class 2 water.
I'm not
He
familiar with
said
that.
it's, yeah, me either.
Like
So
sewage water,
exactly.
drinking water. Okay.
Exactly. So Brandon talked about backed up sewage. So he said amongst mold mitigation experts, subject matter experts, who are the vendors that do this work, it's lingo they use to say, yeah, our water's clean, but it's really pooling. That's probably class 1, class 2. They can extract it, number 1, 2, get it cleaned up properly and dried properly. They would probably opine along with an industrial hygienist that maybe you really don't have to test that. And I don't want to get anybody in trouble. Maybe you do, maybe you don't. But they think that might be the measuring stick. But if that water is what they call class 3, it's darker, it's pooled longer, it has that sewage smell. After you get everything dried up, it may be a lot more crucial to test. So what I really want to clarify is you've got to rely on some third parties. Use your own judgment as a property owner, property manager if you fee manage. Talk to your legal counsel about it and take it on a case basis. What I will say with this slide is I have clients that I really think highly of. They're the kind of landlord I'd want to rent from. If I sold my house right now and wanted to rent a house, awesome people. They'd had their tenants in there for 7 years, thought they had a great relationship. They had a couple pipe leaks go wrong. Insurance wouldn't cover under their homeowner insurance those pipe leaks, but they got people in to repair everything really fast. But I'm really glad they tested in this situation so that they could say to their tenants, we put you up in a hotel, come back on in now. Welcome back. We can give you a clean bill of health. Here's the mold testing. We fixed this water. We've dried it all out and the air spores look really great. I'm glad they did all that because even though these tenants have been there 7 years, they sued them anyway. They moved out, claimed it was just unimaginable. There's all this prior mold that they concealed, things we've been talking about today. They didn't do any of that. Okay, plain and simple. They had never hit anything. They just had a couple unfortunate pipe leaks. And in that limited scenario, I'm glad they tested. Their insurance actually is defending them on this lawsuit because they, lo and behold, have a mold rider. And their defense attorney with Nationwide Insurance told me they were glad that they tested and thinks they have a really solid defense because they did everything they could to meet that 7-day deadline. They had a great vendor. They sealed everything really well, handled all their possessions really well, got them in containers, protected the stuff. They're like the poster child with this new statute being the way it is, doing everything right. And they still got sued. And I feel bad for them on that. So whether you test or not is a tough one, but whether you get the right qualified mitigation contractor in with water intrusion, I think you got to start doing it and spending the money to get the right people in and rely on that trusted source. But it kind of helps to have an industrial hygienist that you know out there. A lot of them will serve as a consultant, give you free advice over the phone, whether you should test in this instance. They may say, no, I think you're fine. They don't all want to make money on you. They want to be your long-term ally. And the industrial hygienists I've talked to, guys, they're super aware of these 2 amendments. They feel bad for landlords. They're not out to rape landlords and just come in and start doing needless testing. I think the right ones will help guide all of us of when to do a mold test. You don't have to do it all the time, and it can open a Pandora's box. But here's what I'll tell you as a litigator. You don't want to be that owner, that property management company that gets accused of covering this stuff up. And then there's a mold test that the tenant goes out and it's not a junk science mold test. And there's levels of Aspergillus niger in the property. That's a bad mold. That's a species, not just a genus of mold, not just a species. That's not good. You just don't want to be caught in that scenario. It's hard to back your way out of it. Tenant would still have to show that they've been harmed by it, but you don't want to be there. Yeah. So I'm glad we got to talk about it. Thank you for letting us address water intrusion because those are the hardest ones to deal with.
No, that's great. And a few comments here I want to highlight. This goes back to talking about you talk about vendors really kind of beefing up their invoices. Mm-hmm. Cheryl, who's also a vendor, said make sure they include photos, which is absolutely a great tip as well. When I've had my stuff remediated, I'm like, all right, they sent me 200 photos. And the more I learn about this, the more I appreciate why. And they show the they've got everything taped off and dropped down. So I think it's a great tip.
That is a great tip. I appreciate her saying that because I looked at a vendor report yesterday, the one I mentioned, where they just needed to add a little more detail. But Chris, they had great photos. And in my world, trying a lot of different cases of different kinds over the years, photos tell great stories. That's universal. That's never going to change. AI is not going to change that.
A photo's worth 1,000 words.
It sure is, sir. It sure is.
And as a note there to Brandon, anyone on the call, Cheryl says she can also help with those category 3 nasty water cleanups as well. So it might be some good connections to anyone out there needs it. But on that note, because I mean, Brandon, we've done a lot the last year, with you and Keyrenter on just, a lot more like education. And I'm a big proponent, especially if these laws have gotten more and more passed. It's making it harder for the smaller landlord, I think, to really effective their manage their property. Talk about how Keyrenter, which is a property management company, like how you guys, are proactive, reduce this and ultimately make a landlord's life hopefully easier and less costly.
Yeah, absolutely. I've always been reluctant to twist anyone's arm or try to fearmonger with this stuff. There's a lot of people who self-manage and do it well, and that's great. And we try to put out information like this to help them do it right. But I think what we just hate to see is people do it sloppy, and they're not actually dedicating enough time to understand these things, to be responsive. I mean, if you're a landlord with a couple properties and you're going to go on vacation and be not available by phone for a couple days, like, you need a process for making sure you've got someone else covering you, that they know these timelines, that they can have access to vendors and get started on things and that kind of thing. So it's just gotten more complex. And we do a lot of work. We manage about 1,100 properties. And we've spent a ton of time lining out processes and educating our team on these timelines, and just making sure we're protecting our clients as much as possible on this. So yeah, we always love to talk to you if it's something you're ready to hand off your property, and we'll do our part to make sure you're compliant with all this.
Yeah, and that kind of goes into part of, like, I mean, you guys are great at, like, kind of doing this portfolio health check where you look at people's properties, look at their rents, like, hey, here's what we see well, here's some things we improve upon. But you guys have always been like, hey, here's value, here's a consult, and when you're ready, we'd love to earn your business.
Totally.
So
open-handed offer here. Yeah. Happy to look over your portfolio and analyze things, see if we see some holes, some areas for improvement, that kind of thing. So feel free to scan that QR code. We won't hard sell you or anything like that. It'll just be hopefully a little value for you.
I've had lots of friends and clients use you guys, and everyone's been happy. All right, so we got a few minutes left, and I want to do some a little more Q&A out here from the chat box, but I know we got like 8 minutes left.
Can I mention one thing?
I was about to ask, go for it. What?
I'd be really remiss and feel bad if I didn't. I don't mean to come across today for all of our folks like Johnny Doomsday here. Like, this is just insurmountable statute to comply with. I hate being that guy. I've kind of learned over the years, we can get through all these things and even navigate a statute. I just saw something in the statute that does give us a ray of hope, and it's right there in 503. On one side of the coin, the negative stuff we really been talking about that I didn't want to read because it's so much legal mumbo jumbo, but it says, there's a rebuttable presumption that the landlord has just screwed the pooch and blown these deadlines if they didn't do all this different stuff. But here's the ray of hope that we have talked about, and I think Brandon did a great job kind of hitting on this a lot. Then that coin turns over and says there's a presumption that a landlord has complied and can defend all this. If I can just find it here really quick. The landlord may rebut that presumption. I love this language, that the landlord has commenced and continued performing. I love that language, continued performing remedial action, but the condition could not be completely remedied or repaired due to circumstances outside the landlord's reasonable control. Some subjective stuff there, but you can see why I wanted to point that out.
Yeah.
That's a ray of hope. Like, to everything we just said, it funnels down to, if you're making that effort, you've commenced and continued, but it's one of these brutal things that you're just not going to get done. That language is in there, and to me, that's a ray of hope. It gives us some real guidance.
Yeah.
All right, so there was a question quite towards the beginning asking, is anyone advocating for landlords at the legislature? I know of three. I think we all kind of, so the Apartment Association, AAMD, and they're, I'd say, a lot more like, corporate, landlords. There's the Colorado Workforce Housing Coalition, which I think all three of us remember. That's how we met, Wes.
Exactly.
And they're a newer group. And
Yes.
I think you're Cheddar and Solzer and those guys are one of the founding members of there.
Yes.
And then there's the
I would say, just to fit it in, because the AMD JLAC stuff is definitely geared towards large apartment,
yes,
institutional investors kind of thing. I would say the Workforce Housing Coalition is a little more, they really took like a bipartisan approach. It's kind of small, a lot of like small multifamily, but they're targeting that like workforce housing. How do we get affordable product out there? And so that's kind of the angle of it. I'll let you continue on the list.
Yeah, that's great. And there's one more. I know they changed their name to Colorado
Housing
Landlord.
It's the Colorado Housing Coalition.
That's what they changed. Okay,
yeah.
So there's three out there. So I mean,
and the CHC, I would say, gears much more
ahead.
towards individual landlords, single family homes. They're tied in closer with NARPM, which is kind of that vein.
I'll throw one more out that I just feel very passionate needs to become an ally to each of the ones you named.
Oh, good.
Yeah, so I sit on this Colorado Bar Association legislative thing for mediation, arbitration. We have tons of sections of the bar, but they all go before what's called the Legislative Policy Committee, and we review bills of all kinds. So one of the biggest sections of the bar is the real estate section, and they have been working on these bills tirelessly. What needs to happen is they've been doing this, but they need to be an even bigger ally with the Apartment Association Metro Denver. So I've known Drew Hamrick, their in-house counsel, for years. Yep. So I want to see that alliance form a little bit stronger because it's a very powerful group, LPC. We bless, fight, all kinds of different bills. They have really worked on some of these bills. But what's scary right now, in my mind, with HOA and landlord legislation, stuff you think isn't going to pass suddenly passes. And I don't get the sausage making part of this. So we need the real estate section to be an ally with each of these groups. And I think maybe this Warranty Habitability Act, maybe everybody needs to talk and have a cleanup bill to tighten it up, clarify some vague things a little bit.
We've seen a little bit of CAR too.
Yeah,
CAR Association of Realtors. They won't touch some of this, but sometimes it starts tipping in. And because the property management license is kind of housed there too, or the property managers have to be licensed as under their thing, they'll get on board with a couple of these things and help us out. But it's tough.
I've been a part of all three, or assisted very, very high level, like across all three organizations. They all do a really good job. They try hard, but they are also resource constrained. Many are kind of part-time volunteers on there as well. So if you guys see one of those groups, join them, donate. Make sure you're paying attention to who you're voting for and what they kind of believe for in the local legislation as well.
Absolutely.
But there are organizations out there, but they need more help, need more money. As with most things, right? So here is a question. Have you seen cases that involved rodent issues on property lines, but not inside the units? Does that fall under warranty of habitability?
Wow.
You talked about the voles. Were they inside the house?
They were inside the house. Big time. That was freaky. I have not seen a case where they've been on the outside and somebody tried to make that as a warranty habitability claim, but I could see it happening. Absolutely. And raises an interesting issue. What do you got to do to get rid of the problem?
Maybe if it was skunks living under the house or something like that, that could be.
But since that question arose, I do want landlords to know there is this new appetite with the personal injury firms to sue for bed bugs, roaches, vermin. We've got this new bed bug statute, and they're just tying that right into premises liability claims. We skipped over one thing in the slides. What damages can these tenants go for?
Yes.
On warranty habitability. I hit it really quick. It's simple. They can go for their economic loss, lost property that's been damaged. Rental abatement's the big one. If it's a really bad situation, they're going to argue that they should get all their rent back. So that's a big number.
Like prior to the issue?
Yes.
Oh, really?
Oh, wow. Really?
The rental abatement is one of the damage components that a tenant can go for. Now, ultimately, if it was a jury trial right now and we're the jury, we could decide how bad was the situation. Are we going to give them any of their rent back, maybe a prorated amount? Maybe it was just 2 months of an 8-month tenancy that was really bad due to this water intrusion, but you can get a rental abatement. You can also get this per diem for food costs, the hotel expenses.
That's something we could do in our 201 as well. As we didn't get into there's a timelines around when it tips into you have to then provide alternate housing, and that now has more complications of you have to match the amount of beds that are in the house.
I did want to say that for a 201, exactly. And then attorney's fees, of course, they can get if they prevail. And when you get hit with these demand letters, the tenant advocacy firms want fees. I get that. So that's going to be part of what you negotiate. Now the issue is, can you go for emotional distress? We were involved in an appellate case called Oberstar. And I think the appellate court's saying, yeah, warranty habitability might give you some distress. And even if it doesn't, smarter attorneys will tie it to premises liability and go for pain and suffering. And what the PI firms that are bringing these bed bug, mold cases, things like that, they like to say to a jury, if we've got a rental abatement, economic damage, give our client double or triple the damage for their economic woes. That's one of the things I've seen used. And Ramos Law Firm won a bed bug case where that was the argument. You get a rental abatement under that. Take the rental abatement and double it and give or triple it and give our client that kind of emotional distress damages. And they won a case in Adams County.
And they got treble damages?
Can't remember what the jury awarded, if it was double the economic loss, but yeah, they at least doubled it. And so that's all out there now as far as what these damage components are. It's a much bigger sword than it used to be.
We'll often see, before it ever gets to that point, sometimes they offer absurd settlement offers, right? Where they're stacking everything they can think of and just inflating it all. I don't know. I guess how do you view those? Like, is that just posturing that's kind of meaningless at times?
Yes, but honestly, Brandon, 7 out of 10 demand letters or complaints I'm seeing now, whether you agree with the liability part of the case, that your client has done everything right, cleaned up the problem, forget about liability. Just on damages, they're pretty reasonable demands. They're going for what property's been lost. They're not asking a ton for emotional distress, pain and suffering, or sometimes they're not asking anything for that. Where I fight with them is on their attorney's fees. Really, you got $30,000 in attorney's fees for writing one demand letter, filing a lawsuit, and that's where the shakedown begins. And you got to really push back as the opposing lawyer on that. But no, I'm not seeing really puffed up ones. Maybe 2 out of 10 can be like that. And you're just like, man, you're way out of line on your damage component, opposing counsel. But the ones I'm seeing, they're much more really based on the rental abatement, what kind of damage the tenant might have had if their stuff was exposed to some form of harm, hotel expenses, stuff like that. Yeah, at least right now, that's been the good news. They're not asking, for the moon. Because when you do defense work, and I've been a plaintiff's attorney in employment law, the worst thing you want to see is just an absolute unreasonable demand. Those are much harder cases to settle, because understandably your client's like, are you kidding me? You want $600,000 for something where you were here for 7 weeks and we let you out of your lease. That just creates a massive problem for me. But right now I'm seeing damage allegations that aren't, completely nuts.
In the tens of thousands or something like that. Yeah.
That could change. We'll see.
So I know we're a few minutes over here, so we'll start wrap up here. And big thank you to everyone. So a couple good parting thoughts on here. I think this is apparently my eyesight's getting better. The Jimena, I probably mispronounced your name on there. Ask, will we be notified of any tweaks or changes with this law as they see as this gets, looking forward in the future? We'll try our best to. I mean, it's very hard. But we're doing more up-to-date webinars. We mentioned some of those organizations, they do publish newsletters and things like that. It's a very fragmented industry in terms of getting information out there.
Yeah, I would say,
but we're trying our best to.
Cheddar Souls or Muccio, is that what they're called these days? They put out probably one of the better. It's not as, I don't know where the status of their newsletter, but they've typically been a good source for regularly kind of filling in the knowledge base for like a individual landlord kind of thing.
Yeah.
You got any recommendations, Wes?
Absolutely. I'm going to help with this because I talk to Pete Muccio constantly, and TSM does do a great job with legislative updates. In other words, here's what's coming. I'm going to know about it through my legislative sources. I'll get with you guys, and yeah, we can find a way to just say, hey, there's a new proposed Senate bill, House bill that's going to amend the Warranty Habitability Act yet again. And again, if I know that there's going to be any kind of a legislative cleanup bill, I'll make everybody I know aware of it.
And I think
Wes,
when there's
if you write it, we'll send it. You got the
There we
hard
go.
job on there.
Yeah,
Sorry,
we'll see
Brandon.
what all the key players want to do with it.
Yeah, I would just say, I don't know how much you meant on this, like this specific law, like how we
Right.
start seeing case law over time and stuff.
Mhm.
I mean, there's no great source for that. That's like the work of an attorney, right? When one of the, you just have to kind of stay up with some of the trends on this to understand the nuance of it.
Yeah, but I guess the punchline is I'll partner with TSM. They do a lot of great webinars, as you know, and they do the newsletter and the blogging, and we'll try to keep people throughout the industry as updated as we can. You're right, it can be fragmented, but I think with these harder bills, everybody that's, you know, trying to help people stay on top of them, we need to let them know what's coming a little quicker, maybe.
And on that note, not to open a new can of worms, but as far as, we're recording this, December 4th or 5th today. I think it's Bill 1090. Which is that the CAMS Act, the junk fees, and it's got all sorts of like, I think, unintentional confusion around like rubs and common area rubs. If you guys are not aware of that as a landlord, holy smokes, get your act
aware
together.
of it tomorrow.
Yesterday, because that goes in effect January 1, and all the lawyers and property managers, investors I talk to, that's the one where it's like, hey, that's the most like urgent one based on the timeline. But
they were hoping for a little bit of a rewrite right before it went into effect. From what I understand, that's not happening. So we got to get compliant, and then hopefully that's coming this spring of some kind of like adjustments on this.
So I know through the Workforce Housing Coalition, I'm all the internal emails on there. People associated with them, they've had some really good conversations with legislators out there, and they're fairly optimistic that they'll be able to kind of get something updated next year. It was kind of like the
great deal
I got. Can't give you any details on there, but they were like, the legislators understood it and were like, yeah, that's not what we meant, is what it sounded like.
Okay. Yeah.
But of course, we all know how legislation works. So good luck to everyone getting that done. But big thank you for coming out. We had almost 100 people on here live, which is fantastic. Big thank you to Brandon. Big thank you to Wes. We will share everyone's contact details and the recording via the email as well. We'll try to get a little bit organized with Wes here as far as like providing, timely legislative updates, because Brandon and I are certainly not experts on there. So it's a big thank you to everyone. If you guys have any questions, need any help, want to talk to Brandon or Wes with their services, let us know, reach out to them. And if you need any referrals, we'll do our best to get you pointed in the right direction. Yeah. But thank you, gentlemen. I appreciate it.
Yeah, thank you both.
Thank you.
Bye, everyone.